10 seconds, 5 seconds, start. The High Court is entitled to satisfy itself as to the correctness or legality or prosperity of any decision or order impugned before it as indicated above. However, to satisfy itself to the regularity, correctness, legality, or prosperity of the impugned decision or the order, the High Court shall not exercise its power as an appellant power to reappreciate or reassess the evidence for coming to a different finding on facts. Revisional power is not and cannot be equated with the power of reconsideration of all questions of fact as a court of first appeal, where the High Court is required to be satisfied that the decision is according to law. It may examine whether the order impugned before it suffers from procedural illegality or irregularity. We thus approve the view of this court in Rukmani as noted by us. The decision of this court in Ramdas must be read as explained above. The reference is answered accordingly. The civil appeals and the special leave petitions shall now be posted before the regular benches for decision in light of the above. In the facts of the present case, when the appellant authority relied upon the Commissioner's report stating that there are 36 rooms in the building and that the majority of the rooms are let out, showing that some of the rooms in the occupation of the landlord are lying vacant. It cannot be said that there is any perversity in this finding of fact. Even assuming that the High Court is correct in its construction of Section 11 of the Kerala Rent Control Act, stating that vacant rooms in other buildings cannot be looked at. This finding of fact of the appellant authority put paid to any bona fide requirement of additional accommodation of the landlord in the facts of the present case. The reliance upon the building tax assessment registered by the appellant authority showing that some of the rooms belonging to the landlord were lying vacant, again is a finding of fact which cannot be interfered with in the manner done by the High Court. Further, the finding that a room leased by the mother-in-law of the tenant in another building is not in the tenant's possession only because he had his mother-in-law's permission to store goods on a temporary basis would also show that he cannot be considered to be in possession of the said room. The contention of the appellants in that case was that such sales were made in the course of export of such aviation spirit out of the territory of India, that they took place outside the state of West Bengal, that in as much as aviation spirit was delivered for consumption outside West Bengal, the sales could not fall within the explanation to clause 1A of Article 286 as it then should. It was held by this court that in order to exclude the taxation by the state of West Bengal, the appellants had to prove that there was some other state where the goods could be